Thanks to Paul Chung for helping me put this together. I'm Kevin Goldberg, and I'm ASNE's legal counsel. And this is sort of, as Paul and I were chatting offline just a minute ago, another effort to bring our expanded legal hotline to the ASNE membership as a benefit that we're offering to you. I think people are aware that we've done a coffee with your counsel session at the past few conventions, which has proven to be pretty popular, even though I missed the last one, so it couldn't have been that great. But you know, that is part of the, as I said earlier, the expanded legal hotline, which has existed for the past couple of years, and is growing now thanks to financial support from the Charles Koch Institute and the Ethics and Excellence in Journalism Foundation. And it's really a way for ASNE members to reach out to me and ask questions. And you can do that year round. As Paul said just a second ago, he asked if it was 24/7. And I said, well, yes and no. I hope you don't call me at 2 in the morning. But that's what it's there for you to call anytime you have questions and reach out to ASNE's legal counsel, me. And I will do the best to sort of get you answers. And that's what we're going to do here over the next few minutes. And that's what we do at Coffee with Your Counsel. So it's, as we say, a 3-part stool to put everything together and get you on firm legal grounds. A couple of rules about this sort of, or guidelines, are that while it says legal hotline and I will be answering your questions, I am not giving legal advice. I am the attorney for ASNE. I'm not the attorney for every individual member. And unless we have an attorney-client relationship, I really can't give you an answer to a specific question through legal hotline. I really can't do pre-publication review. My goal is to give you a better understanding of the issue you are facing, so that you have the ability to go forward and make an informed decision about what you want to do. And what that may be is, I really now know that I need to hire a lawyer. And yeah, I get it. I understand that your budget for legal matters, especially those where it's an access issue and you would have to expend money rather than, to go on the offensive rather than defend yourself, is limited. So you really want to be sure that it's worthwhile. But maybe what we do is we figure out that this is the time that it's really worthwhile, or you do need an attorney. So with that, I have some questions that have been sort of pre-asked, but I would welcome anyone to ask questions that they have now. I would gladly take those first that come through the ASNE Twitter account, and that's @NewsEditors. So you can tweet to us, again, the ASNE account @NewsEditors, with any questions you have over the next 30 to 45 minutes. And let's hope this goes really well, because I'd love to do it on a more regular basis. Again, you can always ask me questions, but I would love to be able to do this maybe once a quarter for you all, and really get a conversation going. I hope that what we get through the Twitter account are follow-ups to some of the questions. And as we await those first questions, I will first apologize for my voice. I have a bit of a cold, but also go to one of our pre-asked questions. And the one I like best actually right now, we'll start it off with something general, is, if we could all do one thing to make your job as a First Amendment lawyer easier, what would it be? Well, yeah, that's sort of a softball, so it's a nice one to ease in. I would say be active in reaching out to me. We're a little selective in what we can and cannot do as a national organization, again, with our own limited resources at times. I mean, we are, we can't be everywhere at once, but we try. And so we try to be very, very efficient in what we do and try to focus on national issues first. But by all means, if you have a local issue where you think ASNE could be of assistance, and again, we won't come in and try to lead the fight, but we would be happy to support you in your efforts in any way possible. If you've got an amicus brief you'd like us to sign on to that's going to help you, or a sign-on letter at the local level, or again, you need background, please come to us and reach out to me at goldberg@fhhlaw.com or 703-812-0462, or just go through the ASNE webpage to the legal hotline. I also would love to see people get more active in their, on their pages. There's largely been a, sort of a feeling, I think, for a long time that, it's a bit of inside baseball to cover issues relating to journalism and freedom of the press. And I think we're now realizing more than ever that just can't be, that you need to speak out, you need to be active, and you need to cover these, cover incidents as though they're news. You need to opine on them if you ever expect the public to, explain to the public exactly why these things matter. And again, I can provide some help wherever possible, giving you some talking points on issues or thoughts, or look things over, and give you some ideas, especially in advocacy sense. I'm always happy to give people ideas. It's like, well, there's this case as well that happened in another state, and this is really comparable, and this helps show why it's important that your state has a strong anti-SLAPP law, or why you have mandatory attorney's fees when you go to court to pursue an access request. So that was, as I said, just sort of a general softball and very easy. Let's see what the next good question. Actually, I talked about FOIA, and someone asked a question about, let's see, what trends are you seeing in efforts to restrict public records nationwide? What can we do as an industry to fight that? Or conversely, are there encouraging trends out there? Well, I can find, I've already talked about that. What can you do to fight that or help your situation? That is, become active. I mean, every state has a state press association. If they're not actively lobbying on FOIA or whatever your state's public records law is known as in your state, let them know that you need them to be your voice and get involved, obviously, if they do exist. There's also a number of open government coalitions, like in DC, where I live. I am on the board of the directors of the DC Open Government Coalition. We've been pretty active in pursuing state, changes to our state Freedom of Information Act, or local Freedom of Information law and open records law. In terms of trends, the worst thing I'm seeing now as a way to restrict public records nationwide are people going on the offensive and suing folks who are filing FOIA requests as a means to shut down the request. And we're seeing this in a lot of different ways at the state level. And that's the most troubling, obviously, because that is going to be financial, it's going to be time consuming, it's going to be resource consuming in every way. That is the most troubling thing. And one thing I've seen is that we've actually seen at least one state, maybe a couple now, consider legislation to push back on that and prevent government officials from suing, or anyone else from suing, to shut down a public records request. But that's a really troubling trend. I think another couple things we're seeing at various levels around the country are a lot of activity, obviously, around police records. Body camera video is clearly in the news all over the place. Again, in DC, at our local level, we had legislation in 2015 to create, to outfit everybody on the Metropolitan Police Department police force with body cameras, but then immediately also exempt all the resulting video from the DC FOIA. We pushed back and were able to reach sort of a compromise that at least gives us some chance to access these records. There are varying degrees of things going on around the country. I urge you to go see where your state lies before it gets too late, and especially your local jurisdiction lies, because there's so many different FOIA requests, FOIA laws that may be applicable. Another thing, and so that goes beyond body cameras, though. We're seeing a lot around the identities of officers and trying to protect personal privacies of officers involved in shootings. Saw that in 3 or 4 states recently, and so it's something to keep an eye out on. We're seeing an increased use of GLOMAR, what we call the GLOMAR doctrine at the state level. And for those of you who don't know, it's something that started in the federal FOIA in the 1970s, where in response to a request about information that someone had filed with the Department of the Navy about a decommissioned Russian submarine that apparently had fallen into our hands, the response from the government was, we can neither confirm nor deny the existence of records about this, that you've asked for, because to confirm but say, well, the national security exemption exists, would have basically said, yes, we've gotten our hands on a Russian submarine. So we're and that had for a long time been limited to federal level and strictly national security issues. We're seeing it all over the place regarding personal privacy, police records, a real expansion of this doctrine. It's something that you need to keep an eye out on. The neither confirm nor deny, or if you hear the word GLOMAR, think, okay, this is something we need to be aware of, because it's really going to create a problem. Because of course, if they say the records don't exist, you don't really have the ability to push back and say, but we need the records, the specific exemption notwithstanding, to make your case in court if it gets that far. On the good side, I mentioned attorney's fees earlier, and there's a lot of movement around attorney's fees and the concept of at least greater eligibility to, if not mandatory, attorney's fees at the state level, which is really important. Obviously, as we talked about at the beginning of the hour, it's becoming more and more difficult for any of you to go to court, and certainly it's almost impossible for you to go to court unless you have a reasonable belief that you are going to get attorney's fees paid for. So I think that's a really important trend that we're looking at. And someone has actually talked about writing sort of a model attorney's fees provision that people could use in different states around the country. But that's something that if it's not in your law, you really need to consider getting that passed. So I'd love to hear what other people have to say about that, about things that are happening, good and bad, in their states with regard to the open records laws. Let's see. Also trending. Oh, the biggest threat somebody asked a similar question, the biggest threat you're seeing to open records this year. And I would say, again, that is the biggest new threat is the willingness to try to basically file what I would consider a slap lawsuit to prevent someone from accessing records. What trends have you seen regarding subpoenas being issued to local news organizations in an attempt to get them to reveal reporters' notes and/or confidential sources? Are those threats growing? What should a newsroom do when confronted with a subpoena? A lot of questions there. I would say the first one is, I have not seen a trend one way or the other in the last few years at the state level with regard to subpoenas, the state or local level. That's not to say they don't exist. It's just to say that things haven't changed as to where they were, say, 2 years ago or 5 years ago. Obviously, there's been a lot more focus at the federal level this year due to the fact that the Department of Justice, under the new Attorney General Jeff Sessions, has not ruled out the possibility of subpoenaing journalists, and that there seems to have been at least some backsliding on the changes to the DOJ's voluntary guidelines that affect members, seeking information from members of the media. The bigger trends that we're seeing now, though, are attempts to end run members of the media. Okay, so to go to you may not get the request yourself anymore. What happens is that the request goes to your email provider, your web your web host, your phone company to get records from them about anybody, the different numbers that may have been called to, where someone was talking to a reporter, or a call out from a reporter. And so that's kind of the way things are moving now. There's also kind of, it waned a little bit, but it's picked back up, a trend to, at least a few instances where we've seen people trying to subpoena to get the names of anonymous commenters to your site or your stories. Thankfully, the Dallas Morning News, I think, just won a federal court case that allowed them to continue to shield the identities of commenters to one of their stories, which was a big win, because we see that a lot as well, off and on. What would a newsroom do when confronted with a subpoena? I would say take it seriously. You should be prepared anytime that you're engaging into a promise of confidentiality. So what I would say is, what should a newsroom do when confronted with subpoena is, not make that the first time you've talked about the possibility of a subpoena. That conversation needs to happen the second you discuss, what it is, why you want it to promise confidentiality or accept information, confidential information. And it needs to be a conversation between a number of people, but basically led by the editor. The editor should be involved in, if not every decision, setting the tone and setting the policies, and working with legal counsel of some kind to figure out, understanding what your state law is, understanding what the possibilities are in an individual case about where you may be subpoenaed. It may seem like it's going to be state court, but it might be federal court in certain instances, and you should understand that that's a possibility at all times. We've seen a lot of people covering purely local stories where federal charges end up being brought, and then you are no longer under your state shield law. So even there, knowing your state shield law is important. But I'd say, familiarizing with yourself with the landscape needs to happen now. Understanding who will be involved when you make a process of, a promise of confidentiality needs to happen now. Understanding that you need to rethink all your security and your technology needs to happen now. And then as you go on, you're better equipped to deal with the individual situations and understand the risks for each. Paul, I guess we don't have any questions in yet. Let's see. Any notable libel verdicts out there we should be aware of? Thankfully, no. I would say that we've seen a lot of cases brought. I mean, the most recent thing I can think of, as I had some notes up on my other screen here, is the pink slime case, where it was massive defamation lawsuit brought against Disney, and due to the ABC News stories on what we call pink slime, where it eventually reached settlement, but clearly into the millions of dollars. And really, it's now the question that's being fought out, that was the most recent news story, was whether the company was going to, whether Disney's insurance provider was going to cover the costs of this settlement. So we haven't had any huge verdicts in the last 3 or 4 months that really stood out to me as either financially massive, or more importantly, for my purposes, legally significant. That the landscape isn't changing right now, other than Gawker, which of course is now more than a year ago, but seems to, and in fact, wasn't a defamation case, but an invasion of privacy case, but clearly has emboldened people to sue. Sorry. And I think we've seen that in a lot, come out in a lot of ways. We've seen a lot of threats to sue, obviously, from various people. I think we've seen, especially with regard to the sexual harassment and sexual assault revelations that have been coming out. We'll see a lot of people saying, obviously, if you sue this, or if you publish this, we'll sue you. Most recently, Roy Moore, the Senate candidate from Alabama, making this declaration to the Washington Post. And so, I mean, that there is that sort of feeling, especially among political candidates, I think, that the public would not look badly upon them, or would perhaps even look kindly upon them if they bring a lawsuit against a major media outlet. Of course, none of them have done that, and I think it's quite obvious why. Because the second that lawsuit gets filed, the discovery process would be in play, and eventually, if it gets that far, a lot more comes out than just these sort of initial accusations. And I'm sitting here kind of personally, and this is not that I want anybody to be sued, but kind of personally thinking and hoping that Roy Moore actually follows through on that lawsuit, because I think it would just backfire completely. But there's a lot I do not know about that particular situation, those the background of those stories. I'm just saying that's an example of where I think that's a lot of bluster, but you have to take it seriously, and it's concerning. And so really, that's what we are seeing. We're seeing a lot of threats, and we are seeing more lawsuits. I mean, obviously, Sarah Palin suing the New York Times, she lost, but that still isn't over. And these things, I think there is clearly the emboldening of potential plaintiffs to, if nothing else, speak out and try to impugn your credibility over and over and over. And nobody remembers that they didn't bring a lawsuit. They remember that they attacked your, the public remembers that this person or this candidate attacked your credibility. And then 5 months from now, especially if they end up winning their election, that what really stands is this person actually got elected. See, they're the ones who are right. But there are an increase in lawsuits being brought. Let's see. News organizations are facing increasing requests to unpublish content on media websites and in digital archives. What advice can you give an editor or reporter that is getting a request to unpublish? Are you aware of any best practices or guidelines that journalists can adopt? Okay, so this is a big deal kind of around the world, right? The right to be forgotten, which is what's triggered this, a ruling in the European Union involving Spain and and then France and other cases. There was one, that have clearly enshrined a right to be forgotten in that law. And then we saw it move to Canada, and we got really worried here, so much so that ASNE joined amicus briefs that were filed in Europe and in the Canadian Supreme Court to try to, make it clear that there should not be a right to be forgotten anywhere in the world, which basically doesn't remove the content from the website, but at least as it is employed in Europe, forces search engines like Google to delist the stories, which basically means nobody will ever find the story unless they know exactly where to go. But that's not here yet. I think what you get here, there's very little legal backing behind it, especially if it's a truly old story. I mean, so what advice can you do can you give an editor or reporter that is getting a request to unpublish is number one, know what your state statute of limitations is for each potential claim. Usually it's going to be someone's going to say, well, this is defamation or it's invasion of privacy. But most instances, people want things taken down that are embarrassing, not defamatory. If they were defamatory, they'd have spoken out in the first place. So what we're largely talking about, these situations are not legal issues. They are, ethical issues. And as I always like to joke, I'm a lawyer. I do not know or talk about ethics very often. But, so that's got to frame your conversation really is, do we have strictly, why are they asking? Is it a legal concern? If it is a legal concern, has the appropriate statute of limitations run for defamation, for invasion of privacy, for, intentional infliction of emotional distress? The last probably doesn't even exist, but, as a likely claim. And then decide what you're going to do, because taking something down could set a bad precedent. I would say it is better than, say, changing the article to make a correction, because now you're kind of, you're asking for especially if you don't have a legal concern, you're really creating a precedent there that you're going to go back in and change things. And finally, I would say that if you are still within the statute of limitations, which means you could be sued, another thing you need to familiarize yourself with is your state's correction or clarification statute, which may, in a truly financial sense, may dictate your response. So these are laws that exist not in every state, but in most, which say that you can only be sued if the person makes a request for a correction or clarification, or that potential plaintiff could only receive certain damages. For instance, they would not be able to receive the really massive punitive damages if they go directly to court without requesting a correction first. Or if you do the correction, you don't ever have to pay punitive damages no matter what. So these are things that are really important to at least have in the back of your mind, the basics. We do have a question that came in. Thank you very much. How can we make it crystal clear to readers that they are the ones who suffer when public records are exempted from access? Police body cam videos, photos of accused public service, etc. Florida is the sunshine state, but the legislature is whittling away our right to know. Yes, they are. You guys have 700 exemptions. I don't even know how many, and they are just very piecemeal. This is what I talked about earlier. Write about it, okay? And write about it in terms they're going to understand. I think things resonate when you use examples that have happened in your community, or not so distant hypotheticals that have happened in your community. I mean, it's very easy to explain police body cameras right now and how they would hold someone accountable. It probably got a little less easy when a study was recently released, actually from an organization here in DC, that said, it doesn't actually modify police behavior, but you could clearly explain to someone how what you saw on a video, even if the cameras don't modify an officer's behavior, the lack of a camera means this would never have been seen. This would never have been seen. This family would never get justice or even have their day in court. They would have no evidence to go on whatsoever. And I think you have to use real life examples that resonate. As I always say, when I'm speaking, it's like, know your audience and understand what's going to resonate with them in terms of the examples you're using. I think that clearly informs your readership. The best way to inform your readership is to use local examples that have happened where you can say, we didn't have body cameras and therefore we don't know this, or we do have body cameras, but here's what we wouldn't know if we didn't. Or this happened in another state, and here's a clear comparison. One of the things I loved was, and I'm embarrassed to say I'm not even sure it's still up, is there was a Tumblr site called Without FOIA, which kind of went through various things every day and said, without FOIA, and this was federal FOIA, you would not know this. This story would have been redacted, take all these facts out because they were only known through FOIA. And there was a lot of that happened actually in Florida at the genesis of Sunshine Week, back when it was even just Sunshine Sunday. I think one of the things that had the most impact was stories that there was a little icon that said, this story was made possible through use of the freedom of, the state's sunshine law. That sort of thing make the instant connection and the tangible connection, I think, is really important. Let's see. Now we've gotten back to two very specific questions, and I again welcome anybody to tweet to @newseditors to bring us in with new questions. So yes, there was a new question. I just saw that one. Here's one very specific question. Our newsroom broke a major national story. Within 2 hours, Fox had virtually copied 15 inches of it, giving us credit and including a link while stealing the heart of the story. They distributed that across their network, including the local station that is beating us for young mobile readers. Our lawyers said they changed things just enough to avoid losing a copyright suit. Is there anything we can do to protect our exclusive content from the kind of theft, since it is all we have that distinguishes us from the competition? Yeah, that's tough, and I see it a lot. And I mean, at first blush, I would have to see the stories side by side, your 15 inches a copy versus the Fox presentation. I could see ways in which you could still bring a case for copyright infringement. But of course, facts are not copyrightable. Ideas are not copyrightable. The story, topic itself is not copyrightable. What is copyrightable is an original work of authorship fixed in a tangible medium of expression, which is your presentation of the story, your prose, your layout, your marshaling of those facts, so to speak, in a way to create the story. And so it is tough to, I don't know if what they're saying is that they changed words, changed organization, changed everything, but kind of clearly free road and didn't do any of their own writing. But that happens, unfortunately. It happens a lot. There used to be a way to stop it called the hot news doctrine. And it's such a hot news doctrine that it was first created back in 1918, where the International News Service was free riding off AP, basically taking their timely stories back when there really was only wire service to break and distribute news to papers around the country. And the Supreme Court actually said that when it's clear that somebody's free riding off your effort, your labor, your skill, and especially where it's in a topic that is of finite interest and duration, that's where hot news comes from. It's breaking news and they've clearly only free ridden off what you're doing. You might have a claim. And that's really been kind of narrowed down over the years, most recently in 2011, to a point where I don't even think it would help the situation. I just think it's kind of, difficult. You may have to wait and find that one situation where you clearly, they slip up and you clearly are able to get them in their mistake, because there aren't many things you can do, as far as I can tell, to go after someone like that, because mostly what you're dealing with, I hope, are in facts. And as I said at the beginning, facts are not copyrightable. So now I'm at my last pre-submitted question, which means we're closer. We had this tag for half an hour to 45 minutes. So we'll definitely make our half-hour point, which is great. But I welcome everybody to, again, submit questions still through Twitter, tweet to @newseditors, if you have any other questions or want to follow up on things I've already said. This last question, something very specific. After the Oroville Dam crisis in California earlier this year, major evacuation because of fear the emergency spillway would give out, state dam officials initially released requested information about inspections. In response to follow-up requests, they then released only after heavy redactions. The state, responding under the California Public Records Act, relied on a Federal Energy Regulatory Commission Critical Energy Infrastructure Information Rule passed in the aftermath of 9/11 to redact the documents. Can a state agency with its own PRA requirements rely on a federal rule to redact? That is a super complex question that can boil down to one thing, a one-word answer. Yes, they actually can. In certain instances, they can. If the state had information that it obtained from the federal government agency can call the shots as to when the state can give out that information. And you're right, it comes in the aftermath of 9/11, the Critical Infrastructure Information Act, and it really is something we fought against but lost on at the time. So yeah, that's really unfortunate. And I would continue to plug away at the things that may not have come from the federal government and are strictly held in state hands. Obviously, that I realize why you want the FERC information, not just the California information. But I also say that it's not. Yeah, there is a provision in the federal law that allows in these instances for a federal government agency to give information, share information with a state agency and say, and by the way, you cannot give this out as a result of our giving it to you. So unless we have more questions, I will, I guess, start to wrap up by reminding people that this is really kind of the first, and we hope not the last, live hangout where you have the opportunity to ask me questions. Otherwise, feel free to use the legal hotline, which you can access through the website. And there's a special legal hotline page. Feel free to email me at goldberg@fhhlaw.com or call me at 703-812-0462. And I'll do my best to answer your questions. And, this is, like I said, part of a way to sort of cross-promote the actual legal hotline. We're still planning to do events at the next convention in 2018 where we're going to have another live session. And it's all brought to you thanks to our sponsors on this, the Charles Koch Institute and the Ethics and Excellence in Journalism Foundation. So unless we have any other questions, thank you very much. I hope everybody has a great rest of the week.